How are you doing? Welcome to Lawyers Info Hub. It's a pleasure to always have you on this channel and platform. If you're new here, this is Lawyers Info Hub. It's a platform where we teach law, we share legal tips to help you become better in whatsoever you're doing as a lawyer, as a law student, as a lover of law. So today we're looking at aiding, abetting, and criminal intimidation under our criminal law series. Now we're going to look at this in this context and what you need to prove in court. So when you talk about abatement, what is abatement? Abatement um, is an act of encouraging, inciting, aiding another person. You see, where sometimes, for example, two young guys, one is encouraging another to go steal something, or one is encouraging another person to cause harm or damage. So that person can be cited for what? Abating, because he abated, he instigated the other person to do that which is not right. So abatement is an act of encouraging, inciting, instigating, aiding another person, you know, to commit a crime. So an abater, so such a person is called an abater, and the crime is what? Abating. An abater is an instigator or a setter on, or someone who encourages another to promote, procure a crime to be committed. So abatement is easier to prove than conspiracy because it involves more than overt acts. Yes, it involves more than overt action. Abatement is easier to prove than conspiracy because in conspiracy you have to prove a whole lot. But in abatement, uh, what you need to prove what is quite lesser. Now, in the case of Kaza against the state, is a 2008 7 Nigerian Weekly Law Report, part 1085, 125, at 134, you know, is a issues of abatement was what reeled out in that case. So look out for it. Now, for an accused person to be convicted, for an accused person to be convicted of abatement, look at what the prosecution must prove. The following ingredients must be shown to be present for that person to be convicted. That one, that there was an encouragement, there was an incitement, there was a promotion, there was a procurement of the offense. So there was an encouragement, there was an incitement, there was a setting on, instigation, promotion, or the procurement of what? The offense. Now, this either the encouragement or the incitement or the setting on or the instigation or the promotion, or the procurement of the offense must be, these actions must be what? Positive and unequivocal. They must be specifically addressed to the commission of the offense. Not when the person was instigated to do A and the person ended up to say the culprit is abatement. The instigation, the promotion, the setting on, the procurement must all what be addressed to the commission of the offense in question, not the commission of another offense. And the act abated must be committed in consequence of the abatement. The act abated must be committed in consequence of the abatement. The act must be committed in consequence of the abatement. This person, based on the instigation by his friend, based on the encouragement, based on the promotion, based on the ginger, based on the hype, his friend, by his friend, he did this. He committed this offense. Not that he committed another. So that particular offense must be linked to those encouragement, setting on, promotion, hyping, ginger, as much as you can call it, encouragement. Yeah, so it must be linked. Very important. An accused person must be convicted of the offense of abatement on the proof, by the prosecution of all the acts that I mentioned earlier: encouragement, inciting, setting on, promotion, procurement of the crime, instigation. you know those acts I mentioned, they are in, even in the alternative, are not cumulative. Encouragement here means when you make someone feel brave, confident to do something, to do a wrong. When somebody is hyped, when you're telling someone, go and beat him, you're a big man, you are strong, you're a man. Go and show them you're a man. Go and show them you cannot be ridiculed. Go and in the act of fighting because of your hype, the person kills the other person. You can be liable in abatement. So encouragement, when you make the person feel so confident to do something by giving active what approval in support of crime. When you're giving active approval in support of crime. Incitement on its own also has element of what encouragement. By incitement, the person is provoked by a strong passion or feeling to commit an offense. Where someone is provoked by a strong passion, note it, strong passion or feeling to commit an offense. Then, an instigation or the act of instigation means something happening by the action or conduct of a person who is the starter by the act of instigation. The co-accused is propelled or gingered to commit an offense. How it happens by action. That is incitement. It happens by action or the conduct of a person who is a starter by the act of what instigation. Very important. And the co-accused is now gingered, is being propelled to commit an offense. The case I mentioned earlier, Casa against the state, is very instructive here too. Now, we're looking at when you want to distinguish conspiracy from abatement. So, a conspiracy is distinguished from abatement in that the crime consists of simply in the agreement or confederacy to do some act, no matter whether it is done or not. In conspiracy, you must prove that common intention that these people gathered together, or even if they didn't gather together, they in harmony, in confederacy, together they did this, or they intend to do this, or they connived to do this. But in abatement, the intention is to do a criminal act. Is not a crime itself until something is done amounting to doing or attending to doing some act to carry out the intention. In conspiracy, trying to say in conspiracy, whether that thing they conspired was done or not, you can still be charged for conspiracy. They even conspired to go and steal the wire or to go and steal, and they didn't steal at the end of the day, or they tried to steal, but it didn't work. But in abatement, the intention is to do a criminal act in itself until something is done, or attending to do some act to carry out the intention. So in abatement, that thing must be done. But in conspiracy, whether it's done or not, the conspirators can be held liable. Now, also, the offense of abatement deals only with offenders who may be described as accessories, before the fact or after the fact. So when you talk about abatement, you're looking at people you classify as accessories before the fact or after the fact. Abators must have committed acts or omission which must take place in pursuance of the conspiracy. Even though they conspired, but they went ahead in doing that for the abators. Now, this also brings us to the point to understand the different category between principals in the first degree, accessories before the fact and after the fact, secondary parties, and all of that. So, abatement and conspiracy, though people look at them as similar, but they are very different in their ingredients. While in the case of conspiracy, prior agreement is necessary. It is not so in abatement. So just like I earlier told you, for conspiracy to be to hold or to be said to have happened, prior agreement, those people came to, there was a common intention to do something. But in abatement, they don't need to have common intention. On the charge of abatement of an offense, the initial element is what? Instigation, like I told you, a positive act or omission which constitutes the fact. Very important. Very, very, very important. So let's look at what we call criminal intimidation. To prove criminal intimidation, the prosecution need not establish physical injury to say this person was bruised, was intimidated. But you can see the bruise in proof of the intimidation. No, the need for proof of physical injury suffered by a victim is not an element or ingredient of the offense of criminal intimidation. So the person does not need to have physical injury to show that you bullied him or intimidated him, you know. So it is enough that the prosecution is able to establish that the accused made a threat by which the victim is now thrown into fear of himself or any other person of an instant harm. So threat is enough to prove criminal intimidation. Someone does not need to have physical injury for you to prove criminal intimidation. For the fact that was a threat which caused the person to be, afraid, put the person into fear, or any other person of instant harm is worthy. So, to prove or to establish criminal intimidation, the prosecution needs to prove that the accused threatened the complainant or some other person, that the threat was of some injuries to him. It may not be physical injury, it could be psychological injury, emotional injury, that it was given to cause alarm to him or to cause him not to or omit to do anything which he is legally entitled to. Because of his threat, he couldn't go out of his house again. He was hiding from his house. He couldn't come home because he felt those people were waiting for him at home. So sometimes when you see people go to the police to make petitions, there is threat to life. They are afraid. That threat can make them not to stop sleeping in their house, make them to stop maybe going out at night, make them to wake up early with fears, make them have sleepless nights. These are things to show it must not be physical of a criminal intimidation. So the case of a Chidozie against COP is a 2018 6 Nigeria Weekly Law Report, Part 1615, 373 at 375. Is very instructive in the proving the offense of criminal intimidation. Note that you do not have to have physical injury for the prosecution to now link it to criminal intimidation. For the fact there was a threat and that threat caused you some injury, it must not be physical injury, emotional injury, psychological injury, and it made it to cause alarm to you or to make you not to do the things you were eligible or legally entitled to do. You could have gone out to your house from any type because of that you stopped going to your house, or you stopped going out at a certain point, or you start waking up early because you are afraid those people might come to your house. So these are things that the prosecution can use to prove that actually there was criminal intimidation. So if we looked at aiding and abetting, we've compared it with conspiracy. We also looked at criminal intimidation. We looked at the ingredients. We looked at also what the prosecution need to prove, to get to establish the commit this offense. So I just hope that you've learned something today about aiding and abetting. Sure, we talked about issue of incitement. We talked about the positive actions or the actions in abetting. We talked about conspiracy. We talked about criminal intimidation. So if you have any question, please drop them. We'll answer them. If you're here to subscribe to the channel, please do hit the subscribe button. Share this video. Let someone else hear what we are saying here. My returning subscribers, I thank you for always stopping by, watching this channel. It means a lot to me. Thank you very much. Still have a great time. And you know what? You can always be the best. You can always be the best. The sky can be your stepping stone. Do take care.